The circuit courts seems to be ignoring their own rules. Is it because they have known all along that their system is broken and has been for a very long time? Well, since Ala Shatter's 2013 eviction bill and the use of the circuit court, if they had followed their own rules and followed protocol, would they have rubber-stamped their fate? Is it the reason that as a whole, the litigant in person is ignored in the court? The clique may well have known from the beginning that the system was broken. We knew it, but it took 3 years to get the fact that rateable value, the lacuna, had no place in the circuit court. Likewise, we believe the whole of the 2013 eviction bill has no place in the circuit court and shall be following up on this matter. But in the interim, here are some circuit court rules that are being broken and ignored. Here is food for thought. Why does a civil bill have to be signed? So you can ask the person who signed it. In court, do you stand over the contents of the civil bill? Why do you think civil bills are never signed by the solicitor or the plaintiff? Order 4, Court Seal, 1. The court shall have for use in each county an embossing seal, or, in circumstances in which the office has multiple locations, embossing seals with an appropriate inscription, as directed by the minister, specifying the name of the circuit in connection with which it is to be used. Such seal shall be placed and retained in the custody of the county registrar. It shall not be necessary that any decree, order, warrant or other document shall be signed by the judge, but all such documents shall be authenticated by the seal of the court impressed thereon and the signature of the county registrar. Where by reason of the rearrangement of circuits an embossing seal is not available for a particular circuit court area, then until such time as an embossing seal becomes available, all documents required by Rule 1 of this order to be authenticated by the seal of the court shall be authenticated by the signatures of both the circuit court judge and the county registrar for the said area. Court impressed thereon and the signature of the county registrar. The civil bill for possession is unsealed, unsigned and not stamped. It must be signed by a person for many reasons, but one significant reason is the possible wish of asking that person or the plaintiff if they stand over the contents of the civil bill. Order 11, Issue of Civil Bill, Service and Entry, 1. Save as otherwise provided in these rules, every civil bill shall be signed and presented in duplicate to be issued out of the office of the court in a county having jurisdiction pursuant to these rules, hereinafter referred to as the office. The civil bill which is stamped, sealed and issued in the manner hereinafter set out shall be the original civil bill. The duplicate thereof shall be filed in the office. The civil bill shall, before issue thereof for service, be stamped in the appropriate amount, if any, as prescribed by law, and, where stamping is required by law, if not so stamped, the civil bill and the duplicate civil bill shall have no effect or force. The civil bill is not sealed and requires such. Likewise the civil bill is not stamped, has the correct fee but is unstamped. The civil bill shall be presented to the office, sealed, marked with the record number by the proper officer, and shall thereupon be deemed to be issued, subject to the provisions of Section 7, 6, A, 2, of the Courts Act, 1964, and shall thereafter be entered in the cause book in date and numerical order of issue. At the time of issuing, the proper officer shall mark upon the duplicate civil bill the date of issue, full details in relation to stamping and the record number assigned to the civil bill. No civil bill shall be served until the same shall have been so dated, sealed, stamped and marked. In presenting such civil bill together with the duplicate thereof to the office for issuing, such presentation may be by post or in person. In circumstances in which the civil bill has been presented by post, the proper officer shall return the civil bill to the plaintiff or the plaintiff's solicitor, as appropriate, by ordinary prepaid post. Under Seal of the Court. 10 Idor Met of Claim, 1. In proceedings on bills of exchange, promissory notes or other securities for money, the civil bill shall set forth the dates of the same respectively, the sums for which the same were respectively given, and the sums claimed to be due thereon for principal and interest, and the rate of such interest, the parties to the same respectively, and the dates when the same respectively became due and payable. Sums to be corrected, principal and interest, likewise the dates they became due. I do say that in accordance with the Circuit Court rules, service of the civil bill, 8. Service in accordance with these rules shall be authenticated by affidavit or statutory declaration by the person serving same, and such affidavit or statutory declaration of service of such civil bill shall mention the date on which the Idor Mets referred to in Rule 7 hereof were made, and shall be sworn or declared within a reasonable time of such service having taken place. Such affidavit or statutory declaration may be endorsed on the original document. Commencement, 5. Every civil bill shall be signed by the plaintiff, or by his solicitor, and shall be endorsed with particulars of the plaintiff's demand. SI. Number 312 of 2007. Circuit Court Rules, General, 2007 Rule 6, 6. Order 5 of the Circuit Court Rules is amended by the substitution for Rules 8 and 9 of the following. 8. The consent prescribed by Section 22, 1. B. of the Courts, Supplemental Provisions, Act 1961, which provides for the enlargement of the jurisdiction of the court by consent of the parties, shall be in the form set forth in Form 1 of the Schedule of Forms, and shall be lodged with the county registrar either before or at any time during the hearing. Whenever an action, cause or matter is instituted which the court has not jurisdiction to try and determine, if the want of jurisdiction appears on the face of the originating document, the court shall strike out the action, cause or matter with costs, unless the consent prescribed by Section 22, 1. B. of the Courts, Supplemental Provisions, Act 1961 has been signed. The time is hour I.
Debt Free TV, in association with GetOutOfDebtFree.org.